A very good afternoon to all of you, and welcome to the session on webinar on e-courts and virtual courts in India, a temporary answer or a permanent solution. This is a session organized under the aegis of Society of Constitutional Law and Human Rights. And it is in the series in which we have held a number of webinars and panel discussions on important issues relating to constitutional law and human rights. And as you can see, today's topic, e-courts and virtual courts, we all know judiciary being one of the important elements of constitutional law and protector of the constitutional rights. We all are interested in this particular topic. And if I may say, justice system in India is undergoing a huge reform triggered by COVID-19. And while the legal system in India has been rooted in traditions and practices of the past, with its own aura and grandeur, truly said, Corona times have been an equalizer. Digitization of the justice system have not been new in India and began somewhere in 1990s with the computerization. A major push in this direction was provided by the National Policy and Action Plan for implementation of information and communication technology in the Indian judiciary, 2005, led by Supreme Court Committee. Presently, Honorable Justice D.Y. Chandrachud chairs that particular Supreme Court E-Committee now. And this is a massive project indeed to provide greater access to common man. However, the progress we all are looking at has taken a huge pace right now in these particular times. And if we all see the developments which have happened now, we are talking about video conferencing, we are talking about online hearings, we are talking about online filings, and plenty of things are being done in this scenario. And to address on these particular issues, who could be better than G.R. Raghavender sir? He's with us today. And G.R. Raghavender is a known figure. He is a civil servant from Central Secretariat Service, 1988, and currently posted as Joint Secretary, Department of Justice, Ministry of Law and Justice, Government of India, New Delhi. Previously, he was the Joint Secretary in Department of Indian Industrial Policy and Promotion, Ministry of Commerce and Industry, Government of India from August 15 to January 2017. He has also held additional charge of Director General, National Productivity Council from November 15 to May 2016. Raghavender sir is very passionate about intellectual property rights. As we can see, he writes a lot of stuff on that area, and he is a sought after speaker in intellectual property conferences. He worked as a registrar of copyrights of the Indian Copyright Office from 2007 to 14 and played a key role in introduction of amendments to the Copyright Act in 2012 and introduction of copyright rules in 2013. So without much further ado, over to you, Raghavender sir, for this session. And we are looking forward to hear from you different dimensions of the present scenario of e-courts and whether this is a cloud which is going to be there for a shorter time or it is the future. That is what we all would like to know. By the way, for your information, there are plenty of clouds in Dehradun now, and it has started raining slowly. So over to you for the session.
Yeah, thank you, my friend, Professor Vijay Kumar Singh, Dean Law School, UPS, and also Dr. Ashutosh, for both of you for inviting me to share my thoughts on e-courts projects and how it has been working since 2011, since its introduction. And good afternoon, friends. Welcome to this e-courts lecture. And you all know that the lockdown imposed by the COVID pandemic has totally transformed the justice system. And we have been reading in newspapers, and we are getting a lot of information that how courts are functioning. And that is very, very important during the lockdown time. Despite restricted access to the courts, and justice delivery system is functioning. And the very idea of the e-court system is to make justice delivery system affordable and also cost effective. This is what planned, as Professor Vijay Kumar Singh mentioned just now, when the National Policy and Action Plan for Implementation of Information Communication Technology in Indian Courts was introduced in 2005. But it's a vision document, in fact, envisaged by the E Committee of the Supreme Court in 2005. So what they wanted to transform the system, slowly move from the physical to digital and system by using the information communication technology, and make the justice system affordable and also cost effective. 5 or 6 important things they envisioned during the discussions over introduction of this vision document, and they took it forward. First and foremost of this e-courts project. Then e-court project adopted all these features of the vision document, and it was introduced as a central sector project of Government of India, Department of Justice, Ministry of Law and Justice, in collaboration with the E-Committee of the Supreme Court. Now, every year funds are provided by a Department of Expenditure to the Department of Justice, Ministry of Law and Industry, to implement the various activities envisaged in this e-courts central sector project. So this year, we have a planned budget of 250 crores to complete all initiatives to be completed in the phase 2 this year. Soon phase 2 will be coming. Phase 1 was introduced in 2011 to 2015. What are the important features? The first and foremost thing is computerization of all courts, especially the district and subordinate courts. So providing computer hardware and giving the internet connection, the LAN connection, and the WAN connection, everything was started in 2011 on war footing, and the strict deadlines were given to all the district courts to complete this project. And Supreme Court itself was monitoring with its E-Committee, and each High Court had a computer committee. One judge, one senior judge with that bent of ICT was given the task of driving this e-courts project under the High Court. And High Court in its jurisdiction, all the district courts is covered, and again a computer committee and in the district level. So there was a network of committees, the E-Committee and Computer Committee of High Courts and the district committees. They all planned and executed this. Especially the first and foremost thing is computerization of courts and providing hardware and network facility. Next is, once it is done, connecting all the, each district court was asked to prepare its own website, and e-courts services web portal was launched. So e-court services web portal became heart and soul of entire e-courts project, giving all the services, all the technological tools required for simple functioning of the courts, moving from physical to digital. This happened because of launching of e-court services portal. The moment it was launched, and another portal was launched, that is National Judicial Data Grid. So what is this National Judicial Data Grid? So it gives the mind-boggling, the humongous data of more than 13 million cases all over India at one database it provides. It more than 10 million court orders it provides. If you go and log in, you just Google National Judicial Data Grid, NJDG. That's simple enough. You get a dashboard. So what you see in that dashboard is a humongous data. You just select district NJDG, select Uttarakhand, select Dehradun. You just see what are the cases pending in the Dehradun district. number of criminal cases pending, number of civil cases pending. And then you can go to the small court and see what are the number of criminal cases pending, civil cases pending. And then there is a dashboard which gives analytical data. Cases pending over 1 year, cases pending over 2 years and above, and 3 years to 5 years, 5 years above, 10 years above, like this. So you select any court in Dehradun district court, and just click on a, let us say, 10-year case pending in the Dehradun district. You get a drill down facility from the beginning of filing of the case till now, how many hearings have happened, what are the reasons for giving adjournments. So what are the orders pertaining to those adjournments, what sitting judge has mentioned, what were the arguments of the both sides, everything you come to know. So that is the beauty of this NJDG, and this is being developed. This has become handy to all over India, the courts functioning. And you can also go to NJDG high courts. All 25 high courts, the same facility is there. There are about 45 lakh cases are pending in the high courts, and 3.24 crore cases pending in district and subordinated courts. More than 2 crores out of this 3.24 is criminal cases pending. The reasons for criminal cases pending, because of prosecution delays and all that. That's what a new project is coming up to reduce the delays happening in the criminal justice system. So I'll just come to that. And then next major activity in the e-court system is make courts. If you go to Dehradun district court, it should be citizen-centric, court. So for that, various kiosks have been set up, electronic kiosks. Those the law students, those who have visited district courts, or if you are not visited, one day you take a walk on Saturday, go to any district court and see. You see the electronic kiosk with the smart screen. You can touch and find out where is the cause list. So in which court the cases are coming, and all this information with the touch of your finger. You can get all this information. These things, these kiosks, electronic kiosks have been installed, and most of the district courts, that's what the e-courts project envisaged. So introducing a citizen-centric district courts with the kiosks installed, and imparting the information about the case management system and court management system, not only to the lawyers, also to the litigants. So a lawyer can't fool a litigant, abhi aa jayega, ho jayega, and all this kind of talks. So, and simply the litigant go and search what is the status of his case and what time in which court hall this coming. So he can see the cause list and find out. He need not go to walk up to the court hall and see on the wall the pasted physical copy. No, at the gate of the court only you can see that. But this facility is available if one can download the e-court services app. I'll come to that app later. And then one more important reform introduced under the e-courts phase 1 is introducing a robust court management system. Under this, digitization of all the records, electronic management system, justice management system. So digitizing all records is important thing that has been done in most of the district court complexes. This has been achieved. And one more thing is change management system. When the new technologies, new hardwares, new systems, so new softwares are introduced. So all judges are not computer savvy or ICT savvy. So how will they learn? So that is the reason why the fifth element of e-court system is train them. So there are master trainers were created out of these judges. So few are young and computer savvy. So what we did, we selected them we train them as a trainers, TOT trainings we give them. We declare them as a master trainers. Yesterday only there was a master training program happened, and each master trainer again has to train more trainers. Yesterday, each master trainer, each person, for example, in Delhi and Mumbai, I'm giving you example. I spoke to both these master trainers. One is Mr. Abhilash Malhotra. He's senior civil judge in Tisajari Court in Delhi. And Mr. Nikhil Gupta is a senior judicial officer in Mumbai City Civil Courts. Now he's posted in Mumbai High Court. So these two gentlemen trained 40 judges each. So they made them trainers. So these trainers who are learned from these master trainers will go and conduct training workshop for other judges and also for the lawyers. So this kind of a network of training facility has been created under the change management, under the e-courts, right from the beginning of 2011. Now it's going on. It's a continuous process. So so you must be wondering, when during this COVID pandemic lockdown, how courts have started using, how all the judges have become computer savvy, how this much of massive infrastructure is there with them. So it all started in 2011 with the e-courts phase 1. Now, after 10 years, when COVID attacked us, and it had turned, its pandemic has created havoc in normal functioning of the courts. Now these electronic equipment, the computer hardware equipment, the software installed, the web portals created, that is e-court services portal, all are coming to handy now. Now without any problem, and the courts have started functioning, and because of the system is already at place and functioning, and uninterrupted internet facility is provided. So that is the reason it's functioning. So the vision document did not stop there. It envisaged future. It looked into the future. What should be the future? It envisaged e-filing, electronic filing of affidavits and document anywhere, anytime. So tomorrow you turn out to be a lawyer, a law student, become obviously 90% guys turn out to be lawyers. So you need not go to the courts and stand in the queue at the registration window and file your affidavit or file your document, enter in the register and sign and all that. So this facility has to be provided electronically. That's what it has been envisaged. In the phase 1, 448 courts have been provided with the video conferencing facility. That's what the e-court phase 1 has done. No, it did not stop simply providing the video conferencing system to only the courts. It provided video conferencing system to 342 jails. So why jails need video conferencing system? The inmates of the jail have to be taken every time to the court for recording of witnessing, recording of evidence and various things related to the crimes they committed. Tomorrow, most of these under trials may turn out to be innocents based on the various evidences. So every time taking them to the courts is very expensive, and also it is time consuming. And sometimes these guys, the hardcore criminals, taking them to the courts is very troublesome, and it's not easy for the even experienced policemen to take them in a secured vehicles and then present them before the judges and get the evidence recorded and taking them back. So this was needed. This was needed in the court, in the jails also, this system to be installed. When phase 2 started, 2015 phase 1 and ended, the phase 2 started in 2016 and it concludes now. If you look at the number of video conferencing facilities in the district courts, you'll be surprised. So How come? Because recently we conducted a video conference with all the high courts to know how these systems are working in various districts under these 25 high courts of all India. We got to know very interesting information. So then we realize, okay, the system is already placed, infrastructure available to them. That's why they are using this. 3,240 court complexes. I'm repeating again, 3,240 court complexes have been equipped with video conferencing facility. So that's why during the COVID pandemic times, even though if not all the cases, whether it is a urgent bail matters or some other urgency matter, courts could hear the matter, and advocates presented their case before the judges, and anywhere, anytime they're sitting from the residences at chambers, because it was not allowed to go to the court during the lockdown period. So only the facility of video conferencing helped to justice delivery system to function. So it is possible because these video conferencing facilities were already installed and fully operational with the internet facility in 3,240 complexes. And 1,272 jails, this video conference facility is there. Last year, I just wanted to experience how these things are working. So one weekend, just like this, and Saturday, I spoke to Mr. The concerned, the Director General of Tihar Jail in Delhi, the very famous Tihar Jail, Mr. Amit Kashyap, is the jail Director General. So he said, "Aye, dekh lijiye facilities, how it is working." So I went there and saw literally how these video conferencing facilities are functioning. In the court system, in the criminal justice system, protecting the witness is also very, very important, especially when POCSO cases happen, the rape cases happen. We can't bring the child on whom these atrocities have been committed, or the woman on whom these atrocities have been committed, before the perpetrator of this violence or crime. So witness protection centers have been opened. Many courts, these facilities there in Delhi, all 6 major court complexes, this witness protection center is there. So what is this witness protection center and how it is connected with the e-courts? It has a special video conference facility. The kid who is suffered and it is coming under POCSO Act or crime against women happen. So these victims can sit in witness protection center. There's a special video conferencing facility where they will interact with the judges sitting in this facility through video conference. And even though the person who committed this crime there with the judge in that court hall at the time, he can't see the kid or the woman who are giving evidence through the video conferencing. Such protection system has been created, and it is functional, fully functional. And in fact, we are planning to create more such witness protection centers in the in future. So Government of India has submitted a proposal to the 15th Finance Commission to provide more funds to the state governments so that they can set up these witness protection centers with the video conference facility equipped, especially in each and every court, because we need such system to be established in each and every court. Maybe it may not be fully utilized sometimes, but still, even though 10 or 15 days it is needed, and then that a separate room should be there, separate video conference facilities should be there, and other facilities should be there. That's what the policy under the e-courts project is envisaged to implement that. And then most important thing is spread of yeah, this ICT facility. While implementing the e-code services phase 2, we have come to know that what has been provided in the e-codes phase 1 has become outdated. We started with 2 Mbps WAN connection in each district code. That is not sufficient. We need upgradation of that. So at least from 2 to minimum 10 Mbps should be there, and based on the capacity and number of judges and number of court halls, this has to be increased to 40 Mbps or 60 or 90, whatever it may be. So Gujarat has been far ahead in this matter. They took up this, and they have increased the WAN facility and more than 300 codes there. So leaving Gujarat, in phase 2, we identified 2,292 code complexes, which this WAN facility has to be increased from 2 Mbps to minimum 10, and then more than 60 or 80 or 90, whatever, based on the size of that code complex and the size of the number of judges functioning there, number of court halls are there. So this project has been given to BSNL. So what we did to do the continuous monitoring, we created a web portal. So sitting in my room, I could see that in the whether fiber optic layers have been laid in Dehradun or not. So are these finally got connected with the NIC system, with the code system and all that. So all these things, all data to be monitored by the officer sitting in the Department of Justice. That facility we have provided. And there are, out of these 2,992 code complexes, there are hilly areas. There are many areas in Northeast where laying of fiber optic cables is a big problem. For them, the alternative satellite mode of internet facility, all those been envisaged, that is being provided. So, so far 2,900 code complexes, this upgradation work has been completed, remaining going on. So whatever delay happened in few is because of this thing only, not able to lay fiber optic, and then getting various other out-of-box system to be introduced to get the WAN connection improved. And entire e-code service system functions on the all important areas, just like each judge can go to the when he sits on the court hall, when he opens his desktop, on his docket there is a dashboard appears for him, because he goes to e-code services portal, he logs in, he gets the all important 8 important case management tools. One is he can create schedule using the calendar. He can see the entire history of the case. So he can read the document, he can read the brief, he can see the entire case history. He need not see the physical file. So entire case history he can go. He can see the analytics of the cases placed before him. He can see the cause list. If, for example, in the cause list there are 70 cases listed that particular day. Out of 70, how many motor vehicle accident cases, how many section 38 negotiable instrument act cases, how many land acquisition revenue matter cases, how many cases, other commercial matters or other civil matters. All this analytical data is given before him, and the period of pendency is also given him, whether how many cases are 2-year more pendency, 5-year more pendency, 10-year more pendency. Because in 2016 chief ministers and chief justices conference, a decision has been taken. So 5+0 karna hai. What is 5+0? Any case is pending more than 5 years to bring down to 0 pendency level. So to implement this, area committees have been established. Area committee is now functioning as the Supreme Court. area committees functioning at all 25 high courts, and area committees are functioning at the district courts also. So they focus on the cases pending more than 5 years, 10 years and all that. So how a judge come to know? A court clerk and going to the room, chamber room, and searching the files and making a list. It's a very humongous task. It's a big headache because everything is digitized now. Everything analytics are provided because based on the data already fed in the software. The software name is Case Information System. Case Information System, CIS. This is the software used, and it's an open source software. And it started in the phase 1 as a CIS 3.0. Now they have migrated to the latest version, CIS 2.0. So it has been made interoperable with all the high court websites, and all district courts are connected with this, and entire e-court services portal functions under that. So whatever data, even judges can generate a template, because if some orders are going to be very common, it did not give dictation. That's why the e-court services portal tool, electronic case management tools, it creates a templates and gives to the judge. He simply has to fill the names of the parties and the CNR number. So what is the CNR number? This is going to be, when you book a train ticket or when you go to book a flight ticket, the PNR number is very, very important. So when a case is filed, CNR number is very, very important. So it is a case number record. It is called CNR. It is 11-digit number. So when you take this, when a case is registered, immediately each case is allotted the CNR number. So if a judge, the advocate must be having 60 cases in his hand. So he wants that information about a particular case. And so instead of searching that physical file, asking his boy to get that file and all that, he can take the mobile. There is a mobile number, dedicated mobile number. It is called SMS pull. So he's pulling this information. That's why it's called SMS pull. What does he does? So he types that CNR number and sends it as SMS under that dedicated number given, telephone number. He can pull all the information about that particular case. He can see the cause list. He can see the matters, orders, and everything. So link is sent to them by SMS. He can click that and open and see all the information pertaining to that particular case. And then what is the SMS push? So if that particular advocate registers his mobile number in the e-court services portal and e-court services app, there is an app also, e-court services app. You can go and download. I request all the students to download from the Play Store or App Store. You can see just for information, see what kind of data a lawyer can get anywhere, anytime, sitting in his car or sitting in restaurant, sitting in his chamber, sitting in his drawing room, wherever he's sitting, and he not be logging on to the portal through his desktop or laptop. A mobile is enough to go to his My Cases. If registered, there is a section called My Cases. All his 60 or 100 cases which this lawyer is dealing in a particular district court, all this appears with CNR number. So he can check the cause list, he can see the case number, and he can go to the case history. He can drill down below and then see what is the status of the case. Most beauty of this e-court system under the e-court services app, one disruption has been created. Each case he can create a QR code. So for example, one particular case, he creates he downloads that QR code and he pastes that on the physical file. So when he's walking in the court complex or he's busy in some other court hall, but this particular case is coming up in the another court hall after an hour or so. And the matter he is attending here is getting late. He is now worried whether he should continue in this court hall or he has to rush there. So simply scanning that case, he can know that what is the status of the case there, whether the cases before his case, which are under argument, are delayed. So he can say that mine will come only in the next court hall after lunch. I can continue till lunch. I can stay here. Or he can, if it is coming up immediately, because it gives real-time information, he can tell his junior or the partner to go and handle that matter or seek adjournment, whatever reason. So that kind of case management system or a court management system is possible. The scanning this thing and creating a QR code. So all these facilities have been provided under the e-courts portal, and also e-courts services mobile application. So I tell many law professors and the lawyers, please download this. It's easy for law teachers because they can know while teaching, they can give examples how these things, how electronics are being used, ICT facilities are being used in the court system to make the life of a lawyer and litigant easy, and how justice delivery has become simple and has become very cost effective and affordable, and that is very, very important. And not only this facility has been given to litigants and lawyers in the mobile application, so they can, lawyers and litigants go to the e-court services portal on desktop or laptop, or use their mobile application called e-court services app. Similar facility has been given to the judges. I gave you an example earlier, that judge sitting in the court hall on the bench, he looks at the desktop or a laptop and manages the daily affairs. The same tools he can access on the mobile. Just like lawyers and litigants have e-court services app, judges have a justice app. It is called justice app. They can download and then see all the tools which are available, which he accesses through desktop or laptop from the web portal. Same information is fetched on his mobile. Recently World Bank said all these tools have to be at one digital portal, one single platform. For example, access to forms, access to regulations, access to laws. So he should not go out and then see a bare act outside the system. So we have integrated India Code. India Code is a website, web portal, providing more than 800 bare acts, laws, and regulations, and a lot of information about the legislations from the legislative departments, Government of India, Ministry of Law and Justice official website. So if bare act which you buy in the market, maybe a printing mistake there, maybe there. Yeah, but in this you don't find such a mistake. It is a notified original document is available, clearly readable form that a judge can access through the portal or a mobile app called Justice app. Lawyer or litigant can access to the e-courts portal or a mobile app. This facility we have. And another facility we have given to lawyers. Lawyers have to fill up so many forms during the litigation. So they keep saying, oh, no, I'm not getting that form. I'm not getting this form. So we made these forms available on district court website, and the average number of 25 different forms we have made available. And then these forms are to be available on a single platform also, not only the district court website. Now these forms are available in the e-court services portal. And you can go to the e-court services app. There also that downloading facility available. So link has been given there that have been included in the e-court services app. So India Code is there, e-court services app is there. And then in 2018, the then Chief Justice of India, Deepak Mishra, sir, Justice Deepak Mishra, and also the Justice Madan Lokur, the then chairman of the Supreme Court E-Committee, they launched a portal for e-filing, another portal for e-summons. E-filing and e-summons are very, very important to reduce the delay in the justice happening. One of the law commission reports which studied the delays in happening in the criminal justice system, they pointed out 5 important delays. What is the first and foremost delay? If you look at the 2 crore pending cases in the NJDJF district and subordinate courts, 65 to 70% of these 2 crore cases are pending because delay in summons, issuing summons. So, and of course, delay happens filing also. So to remove this has to be, in electronic mode using the various ICT tools. That's what it was envisaged in 2018 when portal was launched. Now e-filing facility is available 24 hours, anywhere, anytime in Delhi district courts and Mumbai district courts. And Delhi High Court also recently on 13th of this month launched e-filing facility from anywhere, anytime, remotely. So lawyer sitting in his chamber, lawyer sitting in his drawing room at home, he can file not only the new petition, the affidavits, consent documents, everything he can file. Supreme Court early this month demonstrated that e-filing 2.0 is going to come. So how it's going to happen? They demonstrated, the demonstration is available on the Supreme Court website. You can go and see that, and also e-payment has been made available. So court fee can be paid through this thing. You can generate a challan of paid this thing, and payment can be made through debit card, credit card, internet banking, and also the UPI facility, and also you can use Paytm. So all kind of platforms have been made available for e-court payment fee. So if somebody files less fee, immediately pop-up appears, and then a defect fee you can identify on this. Once he is registered, that lawyer, you can go and fill up, okay, I've paid 1,000 rupees less or 500 rupees less by mistake. I will pay this remaining amount and finish the matter. And then it shows that your e-filing is complete. And then while filing, the person has to provide both plaintiffs and defendants email numbers and mobile telephone numbers. So immediately the system generated email and SMS alert goes to the other party that such and such case has been filed. And this is the link where you can download the petition, and you communicate to your advocate, and then file a written statement or reply or affidavit or whatever documents you need to file. You do that. So this is the automatic email SMS alert system. Recently, Delhi, we have set up 22 commercial courts for ease of doing business under the enforcing contract. So after e-filing introduced, 302 e-summons have been issued. Sometimes, even delay may happens, people are not that honest. So people may claim that that email ID was wrong, mobile number was wrong, it has not reached. So the serving of summons is not complete. Envisaging this kind of problem, Supreme Court launched a system called NSTEP. What is this NSTEP? It is called National Service Tracking Electronic Process. It's called National Services Tracking Electronic Process, called NSTEP. Under this system, the satellite generated geotagging happens. A portal is there. One app has been created, NSTEP app. So mobiles have been given to the process server. So on that mobile, the process server downloads the app, app has that service document, and then he will go to that particular place, and then he will deliver it, and he will take a photo of that building when delivering, handing over that document to the person, and he will upload and geotag it. So longitude, latitude, time of delivery, everything, place of delivery has been noted there. And then no one can say tomorrow in the code that, sir, I have not received the summons, so I need another 6 months time or 3 months time or whatever. So this kind of delay happens in the justice delivery system. So these things are avoided. First thing is SMS alert is going the moment email reaches, and still there is a doubt on that. The person is already physically also going to deliver this. Take a photograph of the delivery and geotag it. So using space technology for geotagging for the electronic service of summons, and this has been a disruptive mechanism which Supreme Court has envisaged, and this has started functioning mostly after the COVID lockdown. This NSTAP system starts functioning, but during this COVID, we have the rescue of email followed by SMS alert. So, and once the case is filed, how it is allocated to the court judges? Again, e-court services portal comes into the picture. So whether it is physically filed during the physical filing system or electronically filed to the e-filing system, the cases, once the daily cases filed, have to be allocated to the judges. They go to the different judges and they will take up, and then that is given in the cause list. So how this allocation happens? What World Bank says, there should be total transparency and full of integrity in allocation of cases. A senior principal judge will not be giving this because he is intelligent, he can handle, यही कर सकता है, ये कर नहीं पाएगा, or because of some consideration, maybe these kind of allocations should happen. It should happen randomly. For example, 10 cases are there, 10 people are there, so it should be 1, 2, 3, 4, 5, 6. You can't say that 1 and 2 will go to him, 3 and 4 will go to him. No, it's randomly allocated to each and every person. So this has been happening, but what the World Bank said, no, it has to happen through a software-based electronic allocation. That has come into place now. This year we are claiming this implementation of this reform in Delhi and Mumbai. This is already in place in most of the district courts. This automatic random allocation of cases and any human intervention that has been removed. So because no forum shopping happens, advocate can't imagine that, okay, my case will go to Justice X and I can manage with him. That kind of thing cannot happen, because even no one knows that to which bench this case is going, to which judge is going to handle, because it is done electronically, randomly, automatically nowadays. So this is possible because of e-court services 3.1, 3.2 software which has been introduced. And under the e-courts, we have introduced the phase 2. Most disruptive thing is virtual court system has been introduced. I give you an example of a virtual court which was inaugurated to deal with the Motor Vehicle Act cases in Delhi. So you all know that the Motor Vehicle Act cases, driving without license, or small offenses I'm mentioning about the Motor Vehicle Act offenses, or jumping the red light, not wearing the helmet. The policeman will stop you and he will give you a challan. Then you say you argue for that and you will not pay, and then you are allowed to go to the court, and then you will making the chakkar, and then the time of court is wasted. The judge has to concentrate on these things. So if these things are made compoundable, these small offenses, and then Yeah, and physically you're not going to the court or the particular window where you have to stand in the queue and pay this amount because you decided not to pay to the constable or a police officer on the road because of various reasons. And after you become a Bhagwan Buddha, you got the realization, okay, why this headache? I'll pay this amount on the basis of compoundable thing, and then you need not go there and waste time. So this virtual court system allows to pay using the payment gateway, the debit card, credit card, and all that. This has been successfully implemented in Delhi virtual courts, and then many high courts have followed this and introduced virtual courts in their jurisdiction. That's what we have come to know in the last month's monthly quarterly conference, video conference with the 25 various high courts. So this is a disruption which our judges are doing. The great service they are doing to improving the speedy justice and access to justice. And the recent virtual courts 2.0 in Delhi is, even a system automatically photographed by the CCTV photograph traffic violation that is automatically fed into your virtual court based on your registration number of the vehicle, which fetches automatically the person who registered, on whose name is registered. That data is fed in the virtual court, and by email and SMS the challan is sent, and then the moment that challan comes, one can pay can compound that offense and make the payment of fine through online. So all
Hello. Seems we have lost Raghavendra ji. Okay.
Yes, I.
In the meantime, he joins. He was giving a very excellent, understanding about the court system, and who could be better than a joint secretary himself speaking about the initiatives which has actually brought transparency into the system. And you can see these particular measures are not one-off measures. These are the measures which are going to stay and continue, and for betterment and for good of everyone. As we have noticed in the chat box itself, these are all excellent steps which will bring fairness into the whole system, and a lot of accountability will come from this. And as Chief Justice of India, Honorable Justice S.A. Bobde recently launched the Supreme Court e-filing module as a first step towards establishing e-courts, Justice Bobde emphasized the need to change with times and how technology has to be accessible and contribute towards justice delivery system in India. In a webinar recently organized, and Justice Chandrachud spoke about the blended mode, emphasizing that the future has to look for a healthy mixture of hearings in open courts and virtual courts. Virtual courts must be encouraged in the areas where it is most suited. And that is what Mr. Raghavender was pointing out about the traffic courts and challan courts. Definitely, that is a interesting and a very important step. So over to you, Raghavender, sir. Please go ahead.
Yeah, I'm sorry, there was some technical glitch and then it stopped. So recent development I was talking about, it is a Pradyumna Bist case. In a Pradyumna Bist case, Supreme Court ordered that a pilot project of CCTV to be installed in the district courts. Gurgaon was selected for this purpose. And then amicus curiae and the NIC top officials visited the Gurgaon courts, and with a specification, with some certain technical specifications, they installed the CCTV, and it was working excellently. That report was given to Supreme Court, and then Supreme Court ordered that this kind of CCTV with that particular technical specifications has to be installed in all the district court complexes, more than 3,200 district court complexes in India. So we uploaded the technical specifications on Department of Justice website, and then Supreme Court is still monitoring the success of functioning of these CCTVs through the Pradyumna Bist case. And another disruption happened about the live streaming of cases. You must have heard live streaming of cases in Supreme Court. And recently, the West Bengal, Kolkata High Court, there was a live streaming example was there. Even the Telangana High Court in Hyderabad, they started a live streaming. All this live streaming thing came with a PIL filed by a student, law student called Sapnanil Patil, because he wasn't allowed to sit in a court, Supreme Court, when this was happening, because he was an intern. He thought it's a learning process, he can learn it. And he was followed by Indira Jaising and Matthew Nadabra, a senior advocate. All these three people filed a PIL asking Supreme Court to allow live streaming of cases of constitutional importance and of public interest cases to be live streamed. So Supreme Court agreed to that, and at least in the court number 1, this should be happening. They asked the Government of India, Department of Justice to drop the guidelines. So it was an opportune moment for me to interact with the Attorney General K.K. Venugopal, and that guidelines have been finalized with the approval of Law Minister, and then this has been sent to the Supreme Court. Now I heard that a committee has been appointed to further improve the the live streaming SOPs, standard operating procedures. Once SOPs are finalized with this committee, live streaming will be happening in the courts. So this is going to be a disruption, because many cases of constitutional importance, teachers like Vijay Kumar Singh, Ashutosh, and your faculty members, who especially who are teaching the constitution, law, or other matters, can have this live streaming streamed in the classroom. And then once that happens, you can start a discussion with the students, and professor can explain that matter, and make some points, and then ask the students to interact. An interactive session can happen, and in this experience, people from Dehradun can't come to Delhi and sit in the Supreme Court every time. Even being a top number 2 in the ministry, I have to get a pass to go and sit in the court number 1 when my own case is coming, because this notice has to be issued from the Solicitor General's office to the gate, and then only pass is made for me. So normal students, how difficult for them to go and sit. So this facility is coming to your university, in your classroom, in your drawing room. You can watch this and you can gain. When your moot courts are going to be transformed based on this experience. So every student, it is a learning experience. You're going to get a online live experience, because top lawyers, whether it's Harish Salve or Mukul Rohatgi or K.K. Venugopal, the great Attorney General, I like him and respect him so much. He's so humble and down to earth with all his experience and knowledge. Whenever I interact with him, I feel so happy. So this kind of great legal brains standing on their legs and arguing, and it's a great experience for students all over the law schools once this kind of live streaming happens. This is going to happen soon. And another disruption going to happen, that is in the commercial courts. Supreme Court has planned, E-committee especially, to introduce a paperless commercial courts. Now, recently Justice V. Chandrachud, E-committee chairman, explained that his court hall, his bench, his courtroom in Supreme Court has gone paperless, totally paperless. So, and recently Delhi High Court also, almost going paperless. So this, you are going to have paperless courts after digitization, e-filing, e-summons, and all that. This is what e-court services project envisaged. What is the future then? What is the future? Future is the using cutting edge disruptive technologies, make the justice delivery is more simple, more affordable, more cost effective. That's what phase 3 of the e-courts project is coming. What is going to be in the phase 3? Phase 3 is going to adopt the most cutting edge disruptive technologies like artificial intelligence, data analysis, cloud infrastructure, so that with all analytical data of data mining, data analysis, so understand why a particular case is pending for 10 years, 20 years, or 30 years, and what corrective action to be made. So whether this corrective course correction has to be made right from the beginning, amending the legislations, amending the acts, or improving the court management system, or improving the case management system. You need amendments to the Delhi High Court rules, Uttarakhand High Court rules, or Mumbai High Court rules, because improve the case management system. So all these things are good, or improve the prosecution system. One more pet project I told you. I'm talking about the future, phase 3. Now, at present, what are in the hands in the e-courts phase 2 project? The most disruptive thing is happening nowadays. Maybe in a couple of months after lockdown is over, this will be implemented. What is this? This is called ICJS. What is ICJS? ICJS is Interoperable Criminal Justice System. Interoperable Criminal Justice System, ICJS. Because, again, Law Commission said, why more than 2 lakh cases out of 2 crore cases out of 3 crore are criminal criminal cases? So what should be done? So entire ICT is being used in this. Interaction of crime and criminal tracking network system called CCTNC is being introduced. So crime and criminal tracking network system, under that system, entire data is fetched and stored in one database. So data about the e-courts, all criminal cases, and FIR filed in the police stations. So FIR need not be constable taking that physical copy, going to the court, submitting into to the hands of judge. No need. Automatically, that particular case, the click of the button, it opens in the desktop of the judge, and e-presence, the so under trial data, entire under trial data is made available to the judges with the click of the button system with the that is e-presence database, and more important is forensics. Fetching the forensics data is very, very important. It takes its own, those who are criminal law teachers, they know that how much time it takes in forensic labs. It takes its own time. After that also, the test data has to be converted, put in a paper, physical paper, and that has to be presented before the judge. So when this data is automatically made available before the judges do the database, need not be physically traveling from Dehradun to Supreme Court. So that's what Dehradun to the High Court. or any place in Uttarakhand. And apart from forensics, it is about the prosecution. Main reason, apart from this service of summons and lack of FIR document and lack of post-mortem report and all prosecution system, the delays happening. So entire prosecution portal that is getting data is going to be made interoperable with at one place, one data place. Finally, juvenile justice system. So juvenile homes are there. That data, because on the POCSO Act, some various acts, juvenile these things, acts. So that home sites, juvenile home sites are there. So that data also fetched and included in this. So this interoperable criminal justice system going to be a big disruption in bringing down the delays. So what I'm trying to tell you that such a huge network of framework or e-courts are already available. During this, lockdown started in the last week of March, then how courts suddenly started using all these technologies of virtual courts or video record hearings and video hearings or e-filing system, because system already under place, infrastructure already made provided. So this came in handy during the lockdown. So as Justice Chandrachud said ad nauseum many times, life is not going to be in the e-courts totally 100%. There is going to be a hybrid system. Physical courts will be there as usual, but physical courts will be using this system to reduce the delays. For example, one witness is not available that particular day hearing, he will be brought under the video recording, online video. Or one party is not available and not able to travel from Dubai to Uttarakhand, so he'll be coming over the video appearance. So video recording facility, virtual court facility will be helping in such a way, and all documents will be made digital, and this is going to be disruption. So a kind of hybrid system will be there. That is going to transform entire speedy justice, whether it is justice, economic, social, or political, and the main aim of affordable and cost-effective justice delivery system envisaged in the e-courts are already started and going to happen soon. And thank you, Professor Vijay Kumar Singh.
Thank you, sir. I think
also,
it was
Ashutosh Tripathi ji. I think I covered all the important points.
Yeah. Yes, you covered, in fact, everything. And that is what I was telling Ashutosh just a while ago, that how much of information you carry in this particular brain, without referring to anything, you are continuously going on and going on and on. And you have so much of information to share. I must say, we need to have maybe these kinds of session for our students when they join in the next semester, because I believe these information should go to the people at large. Because one of the participants have said and asked this particular question, that what do you think that the poor people are, will they be able to access this electronic system which we are talking about, and how useful that would be to them? Because this is a huge issue which has been coming now, and people have been raising this particular question, that we are saying e-environment, how it will move.
Yeah, Professor Vijay, this has already been started. Last year, our department launched a tele-law scheme. So what is the tele-law scheme? Tele-law scheme gives ICT access to justice to the marginalized people, poor people and women who are below poverty line. Who are above poverty line, poor means they can pay 30 rupees and get this tele-law. And other people below poverty line need not pay 30 rupees. Well, how this works, I'll tell you. In a village, there is a CSC called Common Service Center, run by village level entrepreneur. So there is a paralegal volunteer of this maybe SALSA or DALSA or village level legal service authority, legal cell. This paralegal volunteer go to that marginalized person or a woman who has been suffered or exploited. These people are brought to the CSC, Common Service Center. there is a panel of advocates. They are made to talk to the advocates either by telephone or video conference freely. This is made freely. And that lawyer listens to their trouble and takes a note, and he prepares a petition freely, and pass it on to the lawyer who is registered under the Legal Services Authority, and he will take it as a pro bono based on what the minimum amount paid by this Legal Services Authority. This way, these poor people. So please go and check on our website, Telelaw. This entire how it is working. It is working in more than I think. If I'm correct, in 29,000 panchayats it's working, 29,000 panchayats in India, and 2.5 lakh cases advice have been provided to the poor people. I'm talking, and out of this 2.5 lakh cases, more than 70,000 cases for the women, poor women.
Yeah.
And most of these cases, 30 rupees they are not paid. Is a free legal. So technology, leveraging technology to access to justice to the poor and needy and marginalized people, this has already started. This is the brainchild of our Sri Ravi Shankar Prasad, the Honorable Law Minister, who is also the Minister of
ICT, Information Technology.
Information Technology, under whom these common services centers are there. One day he said in the meeting, why don't you use my common service centers for access to justice? I'm a law minister, I'm an IT minister. So these paralegal volunteers, get these people, I will order this CSC start working for them. So this, union started with both departments, and it has become a great disruption. This is the data, and we get a real-time data every time in the ministry. I'm not dealing with this. Other joint secretary is there who is dealing with this matter. He gets real-time data. How many lawyers, how many CSCs are clearing this and all that. They are already started pro bono lawyering also.
Yeah.
Pro bono. There is an app called Nyaya Bandhu. You can download from Department of Justice website, Nyaya Bandhu. More than 2,000 lawyers have registered. About 800 lawyers have got the work. Free work. They are doing it for the poor people.
I think these are quite wonderful initiatives, and we can all see that a lot of synergy is happening between the departments and across departments, and it is being leveraged for benefit of the poor and the people. And I believe slowly the things will start, because I believe transparency has started happening. Now people are watching the court hearings in their mobile phones, maybe probably in the villages. They don't have to travel to the courts to see and chase their lawyers. They can directly listen and hear as to what their lawyers are doing. I believe a lot of transparency will come into this particular system, and middlemen will go away. This is what will happen over a period. There is one concern of Dr. Balwinder Singh, who points out that in these e-court initiatives and these points which we raise, what is a security feature? Like, for example, how do you protect it from hacking or these kinds of activities, or miscreants or problem creators?
That has been envisaged in the beginning of that. There is a CAPTCHA system is there. So you have to put the CAPTCHA, otherwise very difficult to hack it. Different stages, some CAPTCHA system is there. You have to feed the CAPTCHA and then get that open.
So essentially, the security systems are in there, and they are not easily hacked.
There are placed.
Okay, that's great. But, so that actually.
But for any unscrupulous hacker, we can't help. They can go and hack anything. But it's not that easy that it can be hacked that easily. Yeah.
Correct. So hacking is something which will keep on going. But again, the basic security system which is required, that is very much there. Very good. Sir, there is a question by Shikhar, and he says, how likely the clerks to be affected by e-courts? They are talking about law clerks, basically.
Law clerks, it's going to, it's a learning process from them. If a law student join as a law clerk with a judge, he'll be learning all these things. That's why I'm telling you, before you go and join as a law clerk, open the e-court services portal, navigate it, what are the features are there, download the e-court services app and see what are the features are there. So acclimatize yourself with all these features when you go and work as a law clerk, and judge will not have time to teach you all that. He said,
Yeah,
a ready-made boy, I want a ready-made boy to work under me.
correct.
Yeah,
So I
so
think,
that's what I'm telling you. So go and then see what is the National Judicial Data Grid. Browse it, open it and browse it. Browse the e-court services portal. Download the e-court services app, browse it, and then see the features. How e-filing feature is there, forms feature is there, access to laws feature is there, cause list feature is there. If you have a lawyer friend, ask him to take a print of, generate a QR code and paste that particular case, and then you try to scan it. Whether you, I did it, in fact, I scanned it. It fetches data also mind-boggling. So the moment you scan, you get a real-time data. I demonstrated it before World Bank team as well.
that's a great point which you pointed out, and I'm sure everybody would be developing themselves in this scenario, and they have to develop an agility towards newer things and newer technology. We all are working towards it, and I believe this is the future. So we kept the topic, and we asked that whether it is going to be future or it is temporary. So the wisdom which you shared with us, I can say with conformity right now that it is not going to be temporary. It is the future, and definitely, as Justice Chandrachud pointed out, it has to be in a blended mode. So we are not only talking about only online system, but in fact, hybrid blended online methodology, which we generally in our learning terminology, we call it HBO. So it is going to be an HBO justice. And recently I wrote a piece on Justice 4.0, Justice System 4.0. And if we look at that, it is beyond computerization or digitization of system and processes. It is actually helping administration of justice through utilization of AI and other predictive tools. During one of his interviews at 2017 Deakin Law School conference, Justice Chandrachud said on this particular issue, and I would like to quote him. It is quite an interesting quote, and I'm forcing it and looking at that particular thing as a future. If I look at, then he said, technology is of relevance so far as it promotes efficiency, transparency, and objectivity in public governance in the areas of ensuring rule of law. Innovative technology is to enable us to do what we are doing much better, and to think about use of technology which can bring better cognitive skills such as artificial intelligence. The idea is not to supplant the human brain, but to provide facilitative tools to judges to reassess and process they follow, reassess the work which they do, and to ensure that their outcomes are more predictable and consistent, and ultimately provide wider access to justice to common citizens, unquote. So basically, that is what we are looking at the future. So many things, technology is going to be helpful to everyone, and particularly the court system, I believe, is going to be helpful to everyone. So with this, I think we are close to the end of the session, and would like to thank Raghavender ji for sparing his time. I know he's quite busy with his work. Ministry has not stopped, so they all are working from ministries and from home. And I'm sure this learning is going to be carried forward by our students. And we are going to have this recorded session, and probably we will introduce it into one of our clinical courses so that students know as to what are the e-systems available. And they must know, this is what I feel as the Dean of the Law School. And we will be introducing this particular portion in the course. With this, I would request Ashutosh for further proceeding.
Okay, sir. Thanks a lot, Vijay sir. And thanks a lot, Raghavender sir, for such an amazing lecture. I must say that I am very, very fortunate to listen to you on this particular aspect, because of the simple reason that I am accepting this fact that even I was not knowing so much of the thing which you are telling me. So if this is the position of a teacher, I can easily imagine the position of a student. So as Vijay sir is saying that absolutely we have to do a lot of things on this particular aspect so that more and more people are aware about it. And sir, without any doubt, we must say that we are proud as a nation that our nation is doing such a great thing about this ecosystem, because keeping in mind our population, keeping in mind our diversity, so it's not easy task. It's not at all an easy task, but still keeping in what you are saying and what we are seeing, this is a tremendous job which is done by the department, sir. And at the end of the day, we as a law school should also be part of it by way of little bit of improving our syllabus, as sir has told that we can introduce a clinical course. Similar way, I think these all apps, these all tools which you are telling, I think this must be known to each and every law student of India. Because at the end of the day, when they are going to the court after 5 years, then technology is much more. Maybe it is today less, but as you are saying that after 5 years, it will be much more. So, and then they can't say that we don't know it. So they can't have this excuse that we don't know it. So I think as a law school, we have to do a lot about this particular aspect. So thanks a lot, sir, for your valuable time and your valuable lecture. Thanks a lot, sir.
Thank you. Thank you. Thanks for inviting me. Thanks, Professor Vijay and Ashutosh. Thanks a lot. Stay safe and take care. Thank you.
Thank you, sir.